testimony also?
Yes, sir.
All right, I'm going to have to gather my troops.
Are you prepared to argue on this one first, then?
John, I'm not prepared to argue the law beyond generalities. I have a great deal of case material. As I say, I have not had access to the library to streamline it, as it were. I would be willing to make a general argument, but would reserve the right to submit to the court a memorandum of...
All right, I'm going to rule on both of them until in the morning anyway. I want to hear the argument on both of them this afternoon. There's no more hearing testimony. How about Picano and...
Do that during trial if you want to, Judge.
I thought we had reserved that for during the trial. Now, this is all the testimony to be taken on a motion.
Yes, sir. No, sir, we have some statement testimony that you need to hear and some more Williams rule.
Well, we've got some William rule questions, but they primarily will be not witness testimony, as I understand.
You do have some short testimony.
All right. Well, let's take these two motions to suppress in that order. Now, there's argument on them now, and then we'll...
Judge, will you give me a chance to get Mr. Haggard?
Yes, I think you should, and we're going to proceed now with the argument on the Granger, and Mr. Bundy, you may proceed.
Your Honor, there's a lot of cases in that box, and they all deal with consent search issues.
Yes, sir, I'm sure that there's probably that many more that you've missed.
And I've missed quite a few. We're only dealing with a couple jurisdictions. As I said, I'm going to argue the law broadly because I haven't had an opportunity to complete my research on the status of Florida law, although I'm familiar with the parameters of the consent search issue as they exist here in Florida and those as outlined by the United States Supreme Court and other federal courts.
Well, we really basically set the stage. I'm sure you've read Bustamante.
Yes, sir.
Let's proceed with that, and we'll go from there. And you're not going to be far wrong from Florida law.
Well, I think before I refer to the Bustamante case, I think it's important that the court be put in a position of determining whether it's Florida law that applies or the law of the state where the search occurred. And of course I would argue that from the integrity of this court and the integrity of the court of Florida, that the conflict should be resolved in the manner of adopting the law of the forum state of Florida to determine whether a consent in the search that we've heard testimony in today was freely, voluntarily, and knowingly given.
Well, you've got more of a basic threshold argument as far as that is concerned. This court would have to take into consideration the rulings of the Supreme Court of Utah, Mr. Bundy, as far as the concept is concerned. And the only collateral attack, or something in the nature of a collateral attack, would be a federal argument. As this court conceives the law, I think the state of Utah has ruled on it, and it is a provision of the Constitution that you're well aware of concerning full faith and credit and finality of the arguments as it relates to seizure of the goods under the forum of where they're seized. This court would consider that the only possible collateral approach would be on the basis of some additional federal requirement, maybe not brought to the attention of the Utah court. However, so that the record is patently clear, I'm going to proceed with the concept that both arguments, or all three arguments, are in fact open. and I'm not going to close you out on that. Brevity has never been the keynote of this trial and probably never will be. So I'll hear whatever you have to say.
Well, I think, and I will do my best to acquaint the court with issues that are directly involved in the search, which did not come to the attention, or I would tell the court that these issues did not come to the attention of the Florida Supreme Court, or the Utah Supreme Court. However, I understand that the court has read the Supreme Court opinion, the Utah Supreme Court opinion, and will simply direct the court's attention to the findings of Chief Justice Ellett. And Chief Justice Ellett did not find that the search ruled on by the trial court was legal. The legal finding of Chief Justice Ellett in State v. Bundy was that there was evidence sufficient to justify the judgment of the court. It does not speak to the standards of law in Utah or anywhere else as applied to search and seizure, and the search and seizure issue involved in the Utah case. I think what we have here is simply a badly written opinion, and one which is self-evident, relies on virtually no case law, and a very highly complicated appeal. And so I will say only that I don't believe reading of the Supreme Court opinion is dispositive or in any way persuasive in determining the legality or illegality of the search that occurred, and it's the subject of this motion. Let me go to the Bustamante case because it's so often referred to and because it's so important in consent search cases. And I think that this court must first recognize that in the Bustamante case, the United States Supreme Court narrowly decided the issues before it and concluded that its ruling on whether an advisement was necessary.
She has them. Hey, where is the lady?
Pardon?
Where is the lady?
Where's Mrs. Mary?
She's right across the hall.
Does she have photographs with her or clippings with
I
her?
don't know. You'll have to ask her. She might have them in her purse.
You want to let this young lady step down from the stand and bring her over? If they're of some benefit to us, if you can get them for us, Mr. Simpson.
All I was going to suggest is we've already given them the copies of them. They can use the copies as well as the originals.
Whichever one you have.
Our copies are poor, Your Honor, but
Well, why don't you ask the lady to bring them over? We're not before the jury, and the court could glean something from them, maybe. Would you temporarily excuse this lady for the rule and let her sit here and identify the public? Bring Mrs. Neary over. Lady, if you step down and sit right there, it'd be fine.
Come right over here, please, ma'am. Step up in the witness box, please. Raise your right hand.
And do you solemnly swear that the testimony that you will be the truth, whole truth, and nothing but the truth, so help you God?
You seated?
Mrs. Mary, would you state your full name for the record, please?
Wanda Neary.
All right. And you're the mother of Nita Neary?
I am.
All right. Do you have some newspaper clippings that you've collected
I
with
do.
respect to this case?
I do.
All right, do you have them with you, ma'am?
Yes, I do.
All right, may we see them? So, be put together somehow. You could attach it this way if you want.
Just hired you on the interesting ones that showed us to Bundy.
Yes, fine.
Not
That'd be
concerned
fine.
with the other details.
Other than to show reading content, Your Honor.
Return all to the lady that you can. If we need to make photostats for them to the record, we'll give them. I don't want to